I've got my notes on it.
Take it off the clipboard, put your clipboard on the table.
This is cause number 2014-1784, Shannon William Michael Davis.
Yes, ma'am.
Mr. Davis, you are accused of Class B driving while intoxicated. You came to court on Friday, and you watched the video where I talked to you about your constitutional rights, range of punishment, the types of probation, types of dispositions, and the procedures of this court. Is that correct?
I watched that video.
Following the video, I asked each defendant to make a choice between options 1, 2, and 3. That is, hiring a lawyer, asking for court-appointed counsel, or talking with the prosecutors. Do you remember that you had that choice?
I remember you offered those choices, yes.
And when I called your name, you stood up and you really didn't have a firm choice, but you really had wanted to ask questions. Particularly, you were questioning the court's jurisdiction, etc. I suggested that you needed a lawyer. You basically told me that you still wanted to talk to the prosecutor, and so you did talk to the prosecutor under an option number 3, correct?
I did end up choosing that then, yes.
And then you were not able to reach a resolution on your case. Is that also correct?
That's because I still am pleading guilty, like I did on that day.
What?
I still intend on pleading guilty. This is my proposed plea of guilty.
You do?
Yes, I just had a few questions about the cause and nature of the proceedings, which the DA also wouldn't disclose.
So you want to represent yourself and plead guilty?
I guess you could say that, yes.
Well, you can't guess this. I'm really unsure, sir, what
Okay.
you'd like to do.
I'll represent myself if that's what I have to do to plead guilty, as long as the cause and natures are explained.
What do you mean the cause of nature?
The cause and the nature of the proceedings, of the charges against me.
Cause of the proceedings.
The cause and the nature of the charges.
You are accused of driving while intoxicated. Why don't we just have a formal arraignment, Mr. McCain?
Isn't that what this?
Yes, it's part of it. You may present this information. Right, we are having a formal arraignment in this cause number. Proceed, Mr. McCain.
Cause number 2014-1784, State of Texas versus William Michael Davis. In the name and by the authority of the State of Texas, now comes the undersigned Assistant Criminal District Attorney of Gray County, Texas, upon affidavit hereto attached and made a part hereof, and in behalf of said state, presents in the County Court of Law Number 1 of Gray County, Texas, at the July-August 2014 term of said court, that Davis William Michael, hereinafter called defendant, on or about the 2nd day of June 2014 in the County of Gray and State of Texas, and before the making and filing of this information, did then and there operate a motor vehicle in a public place while the said defendant was intoxicated against the peace and dignity of the state. Signed, John Roberts, Assistant Criminal District Attorney, Gray County, Texas.
Mr. Davis, do you understand the allegation against you? You are accused of Class B driving while intoxicated. On the video, I explained the punishment range for Class B offenses. So do you understand the allegation?
I don't fully understand yet.
Okay. So this is kind of what happened on Friday, and I suggested to you very strongly that you needed an attorney, because if you do not understand this, then I can't go forward and accept a plea. So we did have a chance to talk with the prosecutors. I don't know if they communicated and offered disposition to you or not, but what exactly are you unsure about?
I still haven't heard any. I still need to know what facts the prosecutor has provided to the court.
So at this point, the facts aren't provided to the court. The facts are given to the court or to a jury if a person pleads not guilty and they want the state to prove the case against them. Some cases proceed with dispositions in which the defendant enters a plea of guilty. You have a right to discovery of the state's case, which I explained also on the video. You can ask for a formal discovery docket if, or your attorney can certainly get discovery in the case. But when a person pleads guilty, that is all the evidence I need to find a person guilty. No one is suggesting you should plead guilty. But if you want to put the state to the burden of proof, where they prove that you operated a motor vehicle while intoxicated, that it means you did not have the normal use of your mental or physical faculties by the reason of introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of any of those, or any substance into your body that caused you not to have the normal use of mental or physical faculties. If you operated a vehicle under the influence or being intoxicated in Gray County, Texas on a public highway, that's their burden of proof. Now, if you want them to prove those elements, then you have to have either a bench trial or a jury trial. Dispositions do not require that, because when a person says they're guilty, that's enough evidence in a misdemeanor court for me to find a person guilty.
So again, if I'm trying to plead guilty, can you accept a guilty plea without me knowingly, intelligently, and voluntarily pleading guilty?
No, sir, I can only accept your plea if I believe that you're pleading guilty voluntarily.
Which I don't believe I can voluntarily plead guilty if I'm not disclosed the cause and the nature of the charges.
I do believe you need a lawyer, sir. Okay? And I suggested to you that on Friday, but for some reason you do not want an attorney. You keep telling me you want to represent yourself.
Can I introduce my discovery motion then, before we
We're
proceed?
not to that point yet, sir.
Okay, well, my discovery
But
motion
you
would
can't do this
disclose the
both
cause and the
ways.
nature. If they would answer my discovery request, but
What's your
they won't.
discovery request? I mean, can you just summarize it for me?
Let me grab it real quick.
You need to listen to me before you do that, sir, because I need to explain something to you.
Back to the
Turn
microphone,
around and
just
look
so.
at me. You can either represent yourself or you can have an attorney, but you can't do both, okay? I
Okay,
need to-
I'll represent myself,
Okay,
but I don't
before
want an
you-
attorney.
Before you do that, I need to explain some things to you. If you choose to represent yourself, which is your constitutional right, I have to hold you to the exact standard that I hold a lawyer, meaning you have to be responsible and comply with the Texas Rules of Evidence, the Rules of Criminal Procedure, the Penal Code, all of those matters. Now, how much education have you had, sir?
I'm not really here to answer questions at this time.
Yes, you are, sir. You're here to answer my questions because this is something, as a judge, I am required to do.
I understand English.
How far did you go in school?
I went to a government school until 11th grade.
So, do you have a GED or a high school diploma?
I did immediately get a GED.
All right, do you have any college training?
I have no higher education after that.
Have you studied any sort of legal proceedings or law?
I've looked at some, yes.
Okay. Just a few questions, okay? If we were to, are you going to want a bench trial or a jury trial?
I already feel that you're biased towards the alleged or the plaintiff here, so I'd have to ask for a jury trial if we got to that point.
All right, let's say we're picking a jury like we're going to do today. And you...
I have voir dire questions already.
Okay, how many strikes you get?
How many strikes?
Yes, sir. When we finish voir dire and I say exercise your strikes, how many do you get?
Well, that might be something I'll have to research some
All
more.
right, so you don't know. Let's say we start the trial and you have a very valuable piece of evidence. Let's say you've got a receipt of some sort that actually proves that you were not intoxicated. I don't know. Maybe you could prove that there's one receipt that shows you were at one place for 3 hours and you had one alcoholic beverage and that was 2 hours before your stop. Let's say you have that one receipt that you want to get before this jury to prove that you're not guilty. And you don't have to prove anything, but you could want to offer something. How would you get that in front of the jury?
The whole point, if I was forced into a trial,
No one's forcing you to do anything.
If it came to that point, my whole purpose would be to hold the prosecutor their burden of proof.
So you would not choose to offer any evidence on your own behalf?
Most likely not, yes.
Okay. Let's say that the state starts, or you ask questions and you would like to get a statement in, and the state objects to hearsay. Do you believe that all hearsay is inadmissible?
Most likely.
Well, you're wrong, and there's numerous exceptions to the hearsay rule.
Okay.
Sir, all I'm trying to do is to point out to you that you probably are not well-equipped legally to represent yourself. And
I don't want an attorney that's going to start waiving my rights right off the bat.
Sir, you have a right to a jury trial, and if you told a lawyer you wanted a jury trial, you could have a jury trial. No one's going to force you to do anything, okay? Driving while intoxicated is a serious offense in that it has consequences. So you are absolutely entitled to plead not guilty. You are absolutely entitled to put the state to the burden of proof. I'm just suggesting to you that you need an attorney to help preserve your rights and to help you in this case.
You say that nobody's forcing me to do anything, but I've been forced to come here just off the allegation of somebody, which
Well, that
which you
is
said
true.
isn't evidence.
You are arrested, you are required to come to court. Yeah,
That's force.
okay, I'm forcing you to come to court. What else?
Okay, so should we get to my discovery questions?
No, you need to tell me whether or not you understand that I am trying to explain to you that it is not a good idea for you to represent yourself, that I have to hold you to the exact standard as if you had the knowledge of a lawyer. Meaning, if you stand up and the state objects to something and you don't know what to do, then you don't get it before the jury. You make statements that are not admissible, you don't get that before the jury. You start arguing things that are irrelevant, the state objects and I sustain it, you don't get that before the jury. It's a little bit more complicated than I think you're willing to perceive right now.
Like I said, I'm willing to plead guilty. I just have questions about the cause and nature of the proceedings.
You can represent yourself and you can plead guilty, and there's a discovery docket that I have once a month that the state has to provide discovery of their file to a person, a lawyer, or a defendant representing themselves. No one is, that's your right. You have a right to discovery.
I feel that what you're trying to do is force me into a not guilty plea, which waives certain jurisdictional rights.
No one's ever accused me of forcing them into a not guilty plea. You have the absolute right to plead not guilty. I'm not trying to make you plead guilty or not guilty. I'm just suggesting you need a lawyer. Now, if you demand to represent yourself, if you say, I understand that the consequences of representing myself and this is what I want to do, then I have to let you represent yourself. But I'm just telling you it's not a good idea.
Well, I'd rather represent myself than have an attorney.
Okay, and this will be set for a discovery docket. And you will get your discovery at the discovery docket. Our next discovery docket, I believe, is August the 11th.
It's August the 4th.
August- I'm sorry, August the 4th at 9 o'clock. So, once again, as you put it, yes, as long as your case is pending, you signed a bond and your bond said, I will appear in court when requested. You agreed to that with your bondsman. I'm not
Okay.
forcing you to do it. That was your agreement with your bondsman. When the judge wants you to be in court, you'll be in court, right?
Okay.
Okay, so you'll come back to court at 9 o'clock for your discovery docket,
Okay.
okay? Now, because you're representing yourself, each time that you come to court, I do need to give you a reset letter that you signed for, and you get a copy of that tells you your next court date and what the purpose of the next hearing will be, okay?
Okay.
Do you have any questions?
Aside from continually asking about the cause and nature of the charges?
You will come to a discovery docket and you will be given access to the state's evidence they have in their case against you, okay?
Okay.
Any other questions?
Not at this time.
Sir, please have a seat on the front row until you get your receipt letter.